I want to introduce myself. I'm Tom Hudson with the law firm of Hudson Cook. I have with me my esteemed colleague and partner, Patty Covington. Among Patty's many achievements, she is the current president of the National Association of Dealer Counsel, a 500-lawyer trade association of lawyers who represent car dealers. Patty has a lot of things to her credit that will, I think, impress you. The most impressive for me is always the 8 years spent in-house with CarMax. In the trenches, doing legal work, day in, day out stuff. We've got a relatively small group here, and even though most of you have done what I would do, which is to go hide in the back someplace, I will urge that you stop and ask questions at any point. We have a relatively leisurely presentation, I think, in terms of time. We've got plenty of time to do what we want to do, and we have time for questions. So break in. If the thought hits your mind, you want to talk about something, throw a hand up, and we'll try to stop and discuss issues you want to discuss. Also, any other lawyers in the audience who, Terry O'Loughlin here with Reynolds & Reynolds in charge of compliance there. I think I apologize the name, I'm sorry, with Federal Advocates? Thank you very much, I apologize. So 2 more blood-sucking lawyers in the room to ask questions of. If you've got any questions, I think it's fair to say I'll be sticking around for the entire conference. We'll both be here this evening in the reception hall, and I'm always anxious and happy to talk about legal stuff with anybody who wants to talk. And
take advantage of getting some free legal advice. Always a good thing.
That free word makes me break out in hives sometimes. Yeah.
I know. He gives me the evil eye when I say that.
You know, I thought this stuff was relatively difficult 4 or 5 years ago, this consumer credit compliance stuff, but it's gotten noticeably more difficult in the last couple of 3 years. And one of the first things we have to focus on when we start talking to dealers and sales finance companies and others in this business is who's your sheriff? Because after Dodd-Frank, some dealers get regulated by the Consumer Financial Protection Bureau, other dealers get regulated by the Federal Trade Commission. And the way it shakes down, Patty, stop me if I get this wrong, if you sell and lease cars and you have a service department and you sell all of your retail installment contracts and leases, then you have to salute to the FTC. And if you don't do all those things, then you get parked over with the Bureau. So especially if you keep your contracts, if you're buy here, pay here, you're with the Bureau. If you have no servicing department, so you don't service your vehicles, even if you sell all your paper, you're over at the Bureau. So it matters a little bit who your sheriff is these days. You could end up with the Consumer Financial Protection Bureau, you could end up with the Federal Trade Commission, and there's going to be some lingering Federal Reserve Board jurisdiction. Patty, how come it matters who your sheriff is?
Well, it matters for a couple reasons. The first of which is if you are with the FTC, and again, the FTC is for those dealers that have a service department and they do not keep their paper, so they sell all of their paper to a finance company or other finance source. The FTC is an enforcement agency, so the FTC does not have the power to come in and supervise you, to do examinations. So they're not like a traditional banking regulator type that's going to come in and look under the covers and do audits like you may get from the state. The CFPB, however, if you're subject to that, and again, that's if you have a related finance company to which you sell your installment contracts, or you don't have a service, or you don't have a service department, then you're subject to the Bureau. And the Bureau is not only an enforcement agency, but they're also they have supervisory authority. That means that they can come in and look under the covers. They can conduct audits. They can request reports. They have a lot of information gathering powers, as opposed to the FTC, which does not have that. They also have enforcement, and so that's another key. Both the FTC and the CFPB have rule writing authority, and what that means is there may be a statute, an act like Truth in Lending or the Equal Credit Opportunity Act. In those congressional acts and those laws that Congress has passed, Congress has said, we are going to give the certain agencies the authority to write rules under these laws, and that's going to implement what we want there to happen under these laws. The FTC has that right with respect to auto dealers now under UDAP, Unfair and Deceptive Acts and Practices. So they have the right to write rules for dealers about things they think are unfair or deceptive. And then the Bureau, they have rule writing authority also, but theirs is a whole lot broader. They can write rules under what's known as, like I like to say, UDAP with an extra A, Unfair, Deceptive, and Abusive Acts and Practices. They can do it under Truth in Lending, ECOA. I mean, all of the, the alphabet soup of laws that y'all have heard about in the past. If you're a dealer that's regulated by the FTC, the Federal Reserve Board, which you saw on the last slide that Tom had up, they still maintain some rule writing authority, but with respect of Truth in Lending. And so those would apply to dealers. So it really does matter who your regulator is. It also matters because of really the resources available to these regulators. The FTC, they have, they've been around for a long time, but not only do they have dealers as subjects that are subject to the regulation, but they have a whole host of different types of businesses. The CFPB, on the other hand, they are much larger, much richer than the FTC, have a whole lot more power than the FTC, and they are only focused on creditors, what they're called covered persons, and those are companies that provide a financial product or a financial service to consumers. And so if you're subject to the Bureau, it's definitely more intimidating. It's kind of that 800-pound gorilla than the FTC. So that's another reason why it matters.
Yeah, I have to fess up to mistakes every now and again because occasionally I make one. And I made one a couple of years ago, or maybe longer. When the Dodd-Frank Act was working its way through Congress, NIADA went to Congress and said, wait a minute, we need an exemption from the Bureau's jurisdiction for car dealers. And what the NIADA succeeded in doing was getting an exemption, but only for certain car dealers. Mostly the franchise car dealer crowd found their way out of the jurisdiction of the CFPB. And what happened after that was that the consumer advocates succeeded in getting Congress to make the Federal Trade Commission a tougher regulator. They snuck some language in that gave the Federal Trade Commission some powers that they hadn't had before. So the upshot of the whole thing, as I was thinking about it then, I thought, well, the upshot of this whole thing is that NIADA has spent a lot of political capital here, and I'm not sure that what they've gotten is really worth it because they're still going to be subject to the Federal Trade Commission, and the Federal Trade Commission is going to be stronger now and probably meaner now, and so maybe NIADA hasn't gotten much for their money. I sort of changed my tune about that, though, and it's because of the supervisory aspect that is so important. The Federal Trade Commission doesn't have direct supervisory control over a franchise car dealer the way that, for instance, the Bureau will have over a buy here, pay here dealer, right, or an independent dealer who happens to be subject to the Bureau's jurisdiction.
Right, and that's an important note because, we're talking about supervisory authority, but under Dodd-Frank, there's also a whole host of different tools that the Bureau has to collect information from covered persons. So they could, even if you're not subject to supervision, and I'm going to go into a little bit of detail there as to who's subject to supervision because that's going to be important for y'all. There are certain categories of folks that are subject to it, and like payday lenders are automatically, mortgage originators are automatically subject to it. But then for like everybody else, there's this thing called larger participants. So you have to be a larger participant to be subject to the Bureau's supervisory authority. And that's important, but again, because they can come every year and look under the covers. And they being the Bureau, they have the authority to write a rule that says, these are who we are going to determine our larger participants. They have done that they have a proposed rule right now for debt collectors and credit bureaus, but they haven't written that rule for buy here, pay here's essentially. I expect that this summer, I've kind of gotten some indications that this summer we'll see something in the auto space as far as a proposed rule for a larger participant. Again, the significance is that those folks would be subject to supervision. I don't know that it'll necessarily be in the buy here, pay here space, but I do think it'll be in the auto finance space. because the Bureau does have their eyes on auto finance and buy here, pay here. I may be getting ahead of myself a little bit, but I have a client right now that's subject to a CID. A CID is a civil investigative demand, and that's when the Bureau comes in and says, I want this information from you, and I want it under oath, by the way. So it's a real, you know, it's much more serious than come in and ask for reports or asking for supervision. They want information, and they want it in a manner that the company has to say under oath that it is accurate. And so
it's not exactly a welcome wagon visit.
No. Generally, it's followed by an enforcement action, or generally it's followed by, oh, let's settle this, and this is how much you're going to pay us, and these are the things that you're going to agree to. And then, of course, the company can either do that or they can go to court about it. So it's not a real pleasant experience to have to go through. So it's important to know that the CFPB does have these powers, and that they can ask these questions, come in and get this information from folks. And this summer, I think we'll get a little bit more viewpoint, or a little more understanding as to what they're going to be doing in the auto space. But I think that's coming soon.
Well, when Congress was trying to figure out who they would let the CFPB actually supervise, they picked out the 3 particular industries that you named. And then they also said, CFPB, we're going to let you supervise the larger participants in a bunch of other markets, including the buy here, pay here market. And there was one more, and that was the troublemakers.
Yeah. Oh, yeah.
Now, Congress gave CFPB the authority to collect information from consumers and complaints from consumers. And the CFPB has cast a wide net. You heard in this morning's discussion, panel discussion, that there are cooperative efforts going on with the state attorneys general and with other federal agencies, including the FTC. The CFPB is collecting consumer complaints from all around the country, including complaints, I suspect, from some of the buy here, pay here customers that might be your customers. And the Bureau will have the authority, if it sees enough in the way of complaints, it can decide that that particular person being complained against needs to have this sort of supervisory oversight. And I just call it the troublemaker exception. They can just decide all of a sudden that you're a troublemaker, and by golly, we're going to get direct supervision over your operations. So that's a different way they can get into your operation. Okay. Did we do everything on that last one? We talked about on-site, right?
I think we did.
Okay, Patty, they show up and they knock on the front door. What are they going to want?
Oh,
what are the examiners going to want from us?
Well, I think both on, if you get a CID, again, that's a civil investigative demand, first step in enforcement, or if it's an audit, it's a supervisory audit, they're going to ask first for all your policies and procedures. They want everything that you've got currently in place on all areas, from origination to collection to servicing, and they will want to know who was involved in the making of those policies and procedures. They're also going to want to know what employees have the right to amend them, whether you have some informal policies and procedures that are not written out. So they're gonna want to get a good holistic view as to how your operation deals with compliance, because the CFPB, as much money as they have and as big as they are, there are still a lot of covered persons subject to their jurisdiction. So they have to take a risk-based, and they have stated publicly that they're going to take a risk-based approach to supervising and really enforcement. So if they come into your shop, let's say you're subject to supervision, they come into your shop and you've got everything in nice order, you've got all your policies and procedures in place, they see that you've got controls in place, you've got a compliance officer, you do training, et cetera, et cetera. They're not going to spend a lot of time with you because they're like, well, these folks, from a risk-based perspective, they've got their house pretty clean and pretty neat. So we are less concerned as a CFPB that there's some wrongdoing or some bad stuff that's going to happen with respect to consumers. Now, if you don't have that in place, then at that point you become high risk to them, because they will think that you don't have any controls in place to prevent employees, to prevent overall bad things happening to consumers. And they are very single-minded that they don't want any bad things happening, any abuses, any deception, any kind of taking advantage of consumers. If they have any sense that that is occurring, they're going to be they're going to scrutinize real hard.
I think I have to tell the Terry O'Loughlin story now.
All right, where's Terry?
Terry appears on the panel with us at NABD, and I've been on several other panels with him. The first time he said this, I almost fell out of my chair. I'm sitting there, and Terry's talking to the audience, and he says, I've forgotten who the quote is from. Anything that's worth doing is worth doing badly.
Badly.
And I forgot the source of the quote. But he comes out with this. He says, anything that's worth doing is worth doing badly. And I shot him a look, and he says, wait a minute, I'll explain. What I mean by that is think about the regulators showing up at your shop, and think about them saying, show me your safeguarding manual, show me your red flags manual, show me your privacy policy, show me your what's left? I'm missing one, risk-based pricing.
Yeah, red flags
Show
rule.
me all of these manuals that federal law requires you to have in place. Well, if you have nothing at all of a sudden, all the red lights start flashing, and the regulators get really interested in you because they know you just don't simply give a damn about doing what you're supposed to be doing to comply with all these federal laws. So they get really interested in you all of a sudden. And Terry's point is it's a whole lot better to have something on the shelf, even if it's not perfect, even if maybe it's far from perfect. It's a whole lot better to have something on the shelf that you can point to and say, here's what we did to make our effort to comply with that law. I'll take that one step further, because we tell people, once you have your privacy policy, your safeguarding policy, your red flags, all these things, once you have them, go to your Outlook on your computer and calendar an event 6 months out that says review all manuals. And then 6 months out, when that pops up, take all those manuals down off the shelf and give somebody the job of reading through them, making sure they're still accurate. Are you still dealing with the same vendors you were dealing with back then? Is your computer system set up the same way as it was then? Are you suddenly letting people carry handheld devices all around the lot to do car descriptions and the like? If things have changed, then it's time to bring those policies and procedures up to date. And then when you're done reviewing them, then you attach to the back of them a schedule that says, on such and such a date, so-and-so reviewed this policy. And even if you didn't change it, you've got a record of how frequently you've reviewed it, because that frequent review is one of the things that some of the federal laws require.
Yep. Red flags is one of those, as well as GLBA on your safeguards program. So it's important that when you put it in place, you do go back and look at it and make sure that it's still current. There are a lot of free resources out there. The FTC has got some great stuff on their websites that can help you put policies and procedures together. Really, it starts with looking at the laws that apply, kind of those basic alphabet soup ones. Go to the FTC's website and just kind of, they have a search engine there, and look it up. And they'll provide you with a lot of good information on it as a starting place. I have always advised my clients, to get it scrubbed, to get it looked at by your attorney. That's always a good thing. But if you don't want to go that extra step, cash is tight right now, at least put in some time doing it yourself through these websites. The other thing that I would recommend is a compliance officer. Name somebody in your company, somebody in the dealership, to be responsible for compliance, and give them some authority.
And that's required under two of the laws.
It is. It's required under the red flags rule. You have to have someone there, as well as under GLBA. And so, make that person in charge of those two, as well as all compliance, and do more than lip service. Give them some authority. Give them a little bit of money would be nice too, so they can get a couple of subscriptions to some legal periodicals. They'll know what's going on. But make it their job, because if you give them that authority, you'll have at least one person on staff that's got that kind of perspective in mind. So when you're talking about different things, they'll be thinking about it from a compliance perspective, saying, I don't know if that's a good idea. We might be getting in trouble that way. So that's something I always recommend to my clients.
Now, a couple of things. If you don't have just the basic legal setup, a compliance effort at your dealership, if you will give me your email address, I'll send you just sort of a basics, how to set up a basic legal compliance operation that has maybe 10 or 12 steps, and it's designed to do it in such a way that you keep the cost down as low as you possibly can. I focus on places where you can get stuff that's either free, or if it's not free, it's kind of reasonable. How many people here attended the Federal Trade Commission's roundtables or watched them streaming video? Okay. I'll tell you what, if I'm in the business, if I'm running a car dealership, I think that's something you ought to devote a little time to. You can get the transcripts, I think.
You can actually, I think they have the videos still posted.
I believe they do.
Yeah.
I was going to suggest that they watch them on the video because it really is informative. But it is a real good way to find out what your biggest critics, the consumer advocates, are saying about you and what they are trying to get changed in your business. And they are trying to get several things changed, which leads me around. Here comes a trick question. This isn't in the slides in place. I just dreamed it up a minute or two ago.
He loves to do that to me.
Yeah, I was going to suggest that. What do you think the big efforts, the big pushes for enforcement are going to be on the part of the Bureau and the FTC? What areas do you think they'll hit?
FTC, I think spot delivery.
Spot deliveries.
I think that's FTC.
And you got that from the roundtable. That was a big topic at the roundtable.
Yeah, they were very focused on spot deliveries, very focused on the consumer being aware that when they walked out the door that the financing was not final and that the financing could be pulled back in to either have higher finance terms and or they would have to turn the vehicle back in. That was a really big thing, is disclosure and making sure the customer understood that. The other thing, with respect to the Bureau, what do I think is going to be there? I think it's going to be discrimination, fair lending issues is number one, probably one of the number one things that I think they've got on their minds, which fair lending is ECOA, Equal Credit Opportunity Act. You have to treat persons that are known as protected persons or prohibited basis. In any aspect of the credit transaction, you cannot discriminate, you cannot treat them negatively, and that's going to be relating to origination, to pricing terms, servicing, anything really. And those protected classes are race, religion,
you
color.
Can't possibly name them all.
I can.
There are 13 of them, 11 of them? I can't remember.
I think there's like 7 or 8 of them. But anyway, so there's certain of them that you can't discriminate based on. And there's going to be a big focus on that right now by the Bureau, both on originations and servicing. And that's backed up by the DOJ's Department of Justice. So
I'll tell you where I think that came from, and that was the roundtables and their discussions. They were discussing something that wouldn't particularly be of interest to buy here, pay here dealers, they were talking about dealer markups of the finance charge.
Yep.
And during the roundtables, the discussion of dealer markups of the finance charge got really interesting when all of a sudden the discussion turned to discrimination in the markup and the fact that protected classes might have their finance charge rates marked up to a higher degree than non-protected classes. And not only were those of us in the industry attending the roundtable events, the Bureau sent their people to the roundtable events. They had people out in the audience. And they were listening, and I think they picked up on the discrimination issue there. They had known about it before, I think, but they really got interested at that point.
Yeah, the Bureau has an office that's dedicated to fair lending. So they have an office dedicated to fair lending, service members, and there are a number of other offices. If you think that there's an entire office that's dedicated to fair lending is going to be on their mind. Right now, whenever they come in and do an exam to a covered person, there's always a fair lending person in the room. If a company has a CID, which is, remember, civil investigative demand, they have to go and meet with the Bureau about that. There's a fair lending person sitting in that room. Any of the meetings, internal meetings that are happening, fair lending people they're a part of every single thing. That is going to be a common thread theme you're going to see throughout the Bureau. The other thing is the DOJ I mentioned earlier, Department of Justice, is real focused on fair lending. Just in 2011, they ramped up, I would say, by 300% their fair lending enforcement actions. They are real focused on fair lending. President Obama, he established a task force to root out financial fraud and bad acts in the financial arena, and fair lending is a real important one there. So really, that's a real big focus right now, I think, in this area. The other thing, I have some inside information. Have a fellow, it's a friend that was with one of these agencies and was in a room at a time when they were all chatting, and the Bureau said, we've got buy here, pay here's. Don't worry about buy here, pay here's. We're all over this. They have this industry fairly between their, I don't know what the silly saying is, but they're focused right now on buy here, pay here. They're obviously big ones and little ones. I don't really care what the size is. As Tom said, size really doesn't matter now, because if they think you're a bad player, they're going to come after you. And I don't mean to scare you, but I really do think it's important that you know. No, I don't. Really, I don't. You really know your environment. I mean, I've always said, just growing up, my daddy taught me, know your environment, know what's going around you, because that is going to, it set you up for success or set you up for failure. And the more you know about, who's looking out for you and what are the things you need to be doing, the better off you'll be. And I'll stop lecturing now.
Well, I was looking up at our next slide and thinking, do I really want to tell these people how nerdy I am? And I guess I will. Whenever I travel to a new city, when I'm in a new city on Sunday morning, I go buy a paper and I go down and I read the sports section, I read the editorials, and I look around for the car pages, and then finally I get around to the car ads, because I want to take a look at the car advertisements in the city and see how badly the dealers are doing it. Because car ads are just a wonderful source of entertainment for a compliance lawyer. You see all kinds of stuff.
And the FTC and AGs like those.
Yeah, the FTC, especially the state AGs, like to look at car ads. They've been very, very active in this field for the last couple of years. The typical fines we see levied by the AGs are $200,000 to $300,000 when they take a look at car ads and you're not measuring up. And there are all kinds of problems with the ads. A good example was the one the FTC just came down. This was fairly new territory, but the FTC just came down on the 5 dealers, you heard that mentioned earlier, who were advertising that they would pay off your trade. There are all sorts of issues like that the AGs will pick up on. The use of the word free is one that they don't like at all. The burying disclosures in mouse type is always a bad idea. The AGs, by the way, meet. The AGs meet just like our industry meets. The AGs meet 2 or 3 times a year, and they have their own, I started to say 20 groups, I guess they have a 50 group. But they sit down and talk about their successes in going after various people who have violated the consumer credit laws in their jurisdictions. And they tell stories. And if one of them has nailed a car dealer for $300,000, he's going to say so in one of these meetings. And the rest of the AGs are going to sit there and scratch their heads and say, maybe I ought to start reading those Sunday morning ads myself. So when these folks come in, you can bet your life they're going to be looking at copies of your advertisements, and not only copies of your newspaper advertisements, but all of your other media advertisements, including the Facebook pages that your folks have created. Patty, people can get into trouble with those things.
Oh yeah, I mean, a couple of different ways. One thing I thought you were going towards is like websites. I mean, they'll be looking at your websites too, and they, if a federal regulator does come asking, they will be asking for material relating to your websites. One thing that I know that dealers like to do is give website specials, so that the price on the web is a little bit better than if you come in and just come into the dealership. It's very dangerous to have 2 different pricing formats out there. So if you're doing pricing on the web, you don't want to have, if somebody comes into the dealership, you want to be able to offer them that same amount. There is also, like Tom said, Facebook, Twitter, if you're using any of those. The same laws that apply with respect to print advertising, like TILA, Truth in Lending, with respect to if you advertise a particular payment amount, that's a trigger term, and you have to give other disclosures. And if you do that in the newspaper and you do it on Facebook, you have to have those same disclosures in Facebook that you would have to have in the newspaper. So the rules apply in any media that you use, and you need to keep that in mind when you're using alternative or the more modern ways of doing that.
You folks are letting us wander on. Haven't heard many questions yet. I'll encourage you again if you have questions. Ed, I got one in the back. Jay, you're not permitted to ask questions.
Can you give us your email address so you can send us?
Yes, I will. My email address is T like in Thomas, B like in boy, Hudson like the river, at hudco, HUDCO.com. And if you didn't feel like writing it down, just tap me on the shoulder and I'll give you a business card when we're done. Yes, sir. You want to hold up just a second? Let's get a microphone.
Yeah, we need more questions here. I don't think you want us to drone on and on about all the things that you're going to need to produce. So please, ask questions.
My name's Jim Beam from Shaver Preferred Motors. We sell all our paper to the banks and stuff like that. We're not a buy here, pay here. But my question is, you advertise a vehicle in the newspaper, customer comes in, they have derogatory credit. The bank, charges a fee to us, in order to do the financing. We cannot pass that on to the, consumer. What should we do? Should we pass on the deal? And then second part of my question is there anything ever going to change about that?
Do you want to take that, or you want me to take it?
Yeah, let me tell you what the issue is. You want to charge more for the car because you've got to pay an acquisition fee, basically. You want to do that if you can. Yeah, you can't. That's the short answer. You can't do it. Well, actually, you can, but you have to do it very, very carefully. Here's what you're dealing with is a Truth in Lending Act requirement. And the problem is if you charge more for the car because the customer has bad credit, that additional amount has to be treated as a finance charge for Truth in Lending and Regulation C purposes. And nobody ever does it that way. If you don't do it that way and you're charging more for that car, you've got a Truth in Lending violation. So I'll tell you how you go about doing it legally. I've said this to dealers time and time again. All of them look at me like I've lost my freaking mind, and I probably have. But here's how you do it legally. You determine how many of these deals you're going to have through your dealership. You try to make a guesstimate about how many in a particular period, month, year, whatever it is, you're going to have. And then you figure out what all those acquisition fees are going to cost you, and you build them into the pricing of your entire inventory. If that means bumping the price of all the cars in your inventory $150 a piece or $200 a piece or whatever it is, you treat it just like that aggregate amount. You treat it just like it's the water bill or the power bill or whatever else. You don't allocate that increase to any particular car, and it doesn't show up in any deal jacket. What you're doing is simply increasing the price of your cars to cover a general overhead expense that you then don't pass on to any particular customer. That is the legal way to do it. And I think it's the only legal way to do it. Yes, sir.
Hi, I have a question regarding the advertising. When it comes to web pricing versus the lot price, not for cars, but say you put an ad on Facebook for a service or a auto-related product, could it say mention you saw this on Facebook or you saw this on Twitter? Can you do that?
I don't know. Do you know that?
Probably. I think you probably can do it.
Probably, yeah. I don't really know.
But I would need to. I mean, I'd need to probably think about that one a little more because I'm not. I don't want to say for certain, but I do think you probably can do that.
I'll tell you, I was at a conference of who was it? The Florida Independent Auto Dealers Association, and somebody was giving a presentation on best practices for web advertising for cars, and they showed a web advertisement, and whoever was advertising a particular car had an advertisement that said the price of this car is $9,995 for people with good credit. Nah, you can't do that. You can't do that. You know, they have one price for people with good credit. Somebody comes in with bad credit, price goes up. That's a dead giveaway. And the thing that worries me about something like that, just a second, Joe, the thing that worries me about something like that is that that's on the web, and these folks back in Washington, D.C., these 12-year-old lawyers that they have working for the CFPB, can sit in front of their computers and find that stuff in a big hurry. So I'm particularly worried about web-based advertising and violations that you run into. Joe, sorry.
Just to follow up, the second part of the question about, is that ever going to change? Because it seems like, the banks are, passing these fees on to us. I mean,
yeah. I thought sure I had discouraged you enough with the last answer. I haven't seen any sign it's going to change anytime soon. Yeah, he says because of the credit situation. And, I guess it's possible that if people are arguing for more transparency, what has to happen, though, frankly, is not at the congressional level. That's a change that pretty much has to happen at the state level because in a lot of states, that charge would be, under most state laws, a prepaid finance charge of some sort. And there are a lot of states where you can't charge that kind of finance charge. So you'd have that fight in a bunch of state houses, and you probably also have to do something at the federal level, too.
Yeah, because, I mean, you get strapped in by the maximum finance charge that's allowable under state law. So, I mean, putting it in there, it doesn't really matter. But if you're tapped out as far as how much you can charge in a state, that's where, where the real limitation comes. We have one there, and then we'll come right back to you. I think.
If the lender can pass it on to the dealer, why can't the dealer pass it on to the consumer? Is there a difference between the lender passing it on than it is for a
Because,
dealer?
yeah, because the Truth in Lending Act doesn't govern that part of the transaction.
Yeah,
Has no- yeah.
There's two parts of the transaction. The first is the dealer sells the vehicle on credit to the consumer, and that's the finance transaction that's subject to truth in lending. Then secondly, there's a commercial transaction. The dealer sells that commercial paper, the installment contract, to a finance source, and that's not subject to those consumer laws right there.
You.
Right here.
Okay, thank you. I've got the answer for all your questions. I actually have dealer specialties come in and put a window sticker in my car, and I put the price on my car.
Okay.
So my 03 Tauruses are $89.95, and we can always go down. And I've been doing it for 4 or 5 years.
And you can always go down,
You
you
can always
said?
go down on the price in the negotiation process.
Okay.
Once you find out what you're dealing with. Because we do a little bit of conventional, a little bit of credit acceptance, and a lot of buy here, pay here.
Okay.
So I've been doing that for 5 years, and it's the easiest thing you've ever done. Solves the problem. Just put your prices on the window. Okay?
But you can negotiate down.
You can always negotiate. You know, if the car's 89, because I'll give you 65, you can always negotiate down, or work if you decide to do that.
And how does that happen? I mean, like, who determines who the salesperson?
Well, we don't do it very often. Is my
Okay.
point is, but
Okay.
you can come down. You can never go up.
That's not foolproof. I like that. I like that
Yeah.
better than certainly trying to mark anything up. The the advice we give to buy here, pay here dealers is that they put their cars on the lot, put the prices on them, and never come off the price. The price is the price is the price.
Right.
Is
And
the
we
price.
rarely ever do come off. But,
I
I mean,
was pleased to hear when you say it doesn't happen often, because
Right, so
that'll
if-
get you into trouble.
right. We don't go from 89 to 45. I mean, someone
Here-
may. But,
here's the problem. The Bureau shows up at your lot,
right.
and they look at the transactions you've done for the last 5 years. And they find out that when you've come off the price, you've been coming off the price because people have good credit. And they're going to say, okay, that higher price that you've got posted on the car is in part a proxy for finance charge. That's how they'll argue that.
And oh, by the way,
That's the worry.
And oh, by the way, the person that that got the better price, were white males, between 40 and 50, and so you can potentially get into discrimination issues
So
there
it's
too.
better.
Inadvertently, and
Right.
and they don't care if it's a discrimination, whether it's purposeful or not purposeful, it doesn't matter to them.
So then my question, and again, that's not fail-proof, but it makes the process a lot
It
easier.
does.
And quit selling your cars so cheap. Okay, so going back to the FTC definition, I'm an independent dealer.
Okay.
I have a lease company that's a separate business,
Okay.
and I have a service department. Am I FTC?
You hold your paper.
Do you have a
I
related
have a
finance
lease
company?
company that's a separate leasing company.
But it's related by ownership.
Say it again.
The ownership of both companies,
Same
are they the
ownership.
same
Right,
person?
Yes, yes.
Same
So
ownership.
So that would be
Related by-
considered a related
Yep,
finance
yep,
company.
same-
Okay, so then I would want to, okay, that was
Yep.
my question. Okay, thank you.
Your Bureau affiliated. Yes.
I was advised that I could advertise cash price, and then if I needed to finance the vehicle, and if it was a situation with special financing where there was an acquisition fee, then it would be okay to charge a different price.
A dead bang truth in lending violation. Just no question.
All right, thank you.
Yeah, it sounds like you might have gotten that advice from the guy who's building my house. Yes. Yes.
I've got a couple of dealer friends that are just in love with push-puller drag sales. They're always wanting to give $1,500
Push, pull, or
minimum
drag,
trade.
yeah. Oh, yeah.
And I keep telling them they're in trouble there, but am I right or wrong?
I can't wait for the FTC to crank up on that. You know the thing. How much do they offer? $500 push, pull, or drag, whatever it is. $2,500 push, pull, or drag. Well, you know what they're doing. I mean, it's flim flam that I'm sure the FTC will land on. That's one of those things like we'll pay off your car no matter how much you owe. It's the same kind of deal. It's just a sham transaction. You know, where? Ah,
Okay.
there we
Hi.
go.
So I was wondering with the acquisition fees, if you have them sign some type of disclosure, if they're in agreement and
Nope. Nope, doesn't help a bit.
not at all?
Still got a truth in lending violation. Customer can't agree that you violated the Truth in Lending Act. We can, but it doesn't matter.
Yeah, no.
Yeah.
Well, and they can't waive it. I mean,
Yeah,
you
it's not
can't
in-
waive that consumer protection. Also, if you look in your dealer agreements with the finance sources, there'll be some language in there that the finance source says, if it's a good agreement on their side, that you can't pass along any of those kind of fees.
So you violated the Truth in Lending Act, and your finance company can shove the deal back down your throat if it finds out about it. So that's a double whammy. Wow. Yes, sir.
I would like to know if you're aware of any recent or otherwise actions involving the FTC used car rule, display of buyer's guides, things of that nature.
That's, well, the used car rule. They have had SWAT teams out looking at window stickers on several occasions. We've seen that in the DC area. It's been in the Detroit area, Chicago. They'll go out and take a look at everything on the lot. And there's not much of a trick to that. If the car is for sale, it needs a window sticker in it. Window sticker has to be filled out correctly. You need to get your window stickers from a good source, because it's one of those few things in the federal law that's like this. But the FTC's rule says that the window sticker has to be precisely as it appears in the Federal Register. Same type font, same type size, same color, black on white. You can't have any other junk printed on the window sticker. Forget all that advertising you wanted to put on there. You can't do that. And there's a trick for Spanish language. You want to take that one?
Well, yeah, if you are conducting any of the transactions in Spanish, you have to have the English version and a Spanish version hanging in every car. So you want to make sure that you have a translation of it. Again, your vendor should be able to provide those forms.
Yes, sir.
Yes, I'd like to know if there's any specific trigger for the CFPB, or is it ambiguous as to who they can come after and for what reason?
I think part of that's going to be complaints. They have this new fancy complaint database online, and it's unlike, like, the FTC has something that you can call in or write in or whatever, and they just log complaints. The Bureau has a complaint it's an interface, and so the consumer goes in and makes a complaint. What happens is the CFPB, within a 24 to 48 hour period, will take that complaint and give it to the company that was the subject of the complaint and say, resolve it with your consumer. Fix this. And so the company has 10 days to fix that complaint with the consumer. And then the real fun part is the consumer gets to report into the Bureau and say, well, and tell them what they thought, whether they thought they got a good, it was resolved positively or negatively. And they send that information to the Bureau. And the Bureau's got this thing called a consumer response team. And these are folks that will investigate these complaints. And the way they prioritize what's investigated are when the consumer's not real happy with how the complaint was resolved, those are first on the list. And second on the list are those complaints that the company didn't even bother to answer in the time allotted. And they're second on the list. And they'll go in and talk with the consumer and investigate there. So that will be one method that you get on the Bureau's radar, I think, fairly quickly. They are real focused on complaints.
And the best, by the way, I think most buy here, pay here dealers and most car dealers I've ever known are pretty good about responding to consumer complaints, just because they're responsible business people and they know that's a good business thing to do. From this point on, it is a really, really important thing for you to do, to monitor consumer complaints and keep them off the CFPB's radar. If you can settle that complaint before it hits the CFPB's radar, you don't have to go through all that rigmarole Patty just described, and you don't get a notch on your record at the CFPB.
Yep. Hello. My question is about the window stickers and the forms. Is it nationwide?
It is nationwide with 3 or 4 state exceptions. Wisconsin.
Yeah, I was going to say Utah, but I think it is Wisconsin.
Massachusetts.
I don't remember.
Where are
I'll
you?
be real frank. Massachusetts.
See me out in the booth, and I'll run that down for you. But there are 3 or 4 states that have their own version of that. But for most all states around the country, it's a national requirement, and it's the same requirement everywhere.
Terry?
Okay, thank you, Terry.
Yeah,
I'm glad we brought you along.
2 questions. One is I'm hearing more dealers, areas like California, Texas, where there's more of a Chinese or Asian population. Does it also apply to Asian, the FTC used car rule?
Not yet.
So right now, just
Spanish.
It's just Spanish. All right.
So far, just Spanish for the window sticker.
Question number 2 is information on the back of the used car guide not being filled out. Is there any violation need criteria to be met on the back side?
Well, the rule specifies how it needs to be completed. Like, for instance, you're supposed to identify any warranty if you're given the warranty and what's covered. And so if that's not completed, it does violate the rule. and technically it would be a violation that they could bring. So the information that's required, you have to complete as stated in the rule.
Actually, I now have two questions. Just to follow up on what you were just talking about, is on the back of the buyer's guide, there's a bunch of like check mark areas on possible items that could be wrong with the car. My understanding is that if you know that there is something wrong with the car, you have to fill it out on the back. Am I correct?
That's going to be state law. It's going to be dictated by state law because some states have certain requirements with respect to like prior use or damage to the vehicle that needs to be disclosed. And that's my understanding. I need to go back and look at the rule because I haven't looked at it in a while, at least with respect to this. That I don't think there's a federal requirement that you actually, I'm almost certain there's no federal requirement that you disclose the damage, but that would be state law, and that's where you would put it on the form itself.
Okay.
If you'll stop by and visit with us, we've got a book with a chapter on the window sticker rule in it, and we may well address that question there.
Will do. Now, my original question is, one of the concerns I've been having at this point, we do not have a bilingual salesman. We do have plenty of Hispanics and Asians that come in and purchase cars from us, and probably 10 or 20% of them don't speak English, but their kids are extremely fluent. And sometimes these kids are 4 or 5 or well, probably 6, 7, 8, 9, 10 years old, and they are interpreting for us. And I always
No,
worry
they're
about
interpreting
that.
for their parents. They're not interpreting.
That's
Exactly.
exactly right.
You are correct. So, what is my liability to handle a contract using a minor as an interpreter, even though it is part of their own family?
What state are
or
you
from
in?
Minnesota.
Okay.
Yeah, that's probably not the world's best practice. I can't answer the question, but I'll think about it. Maybe
Well,
we'll
agreed.
talk about
But
that later.
do you tell them to say "hasta la vista, baby," or what?
Now, you know, if they
Let me answer a related question, though, because this may be helpful. There was a Federal Trade Commission guy giving a talk in Chicago 4 or 5 years ago on the rule, and this question about when is a transaction negotiated in Spanish came up, and I raised my hand, and I said, if the customer walks in and the customer has someone with the customer who speaks Spanish and English, and the customer's friend translates, and the dealership people speak nothing but English, is that a transaction in Spanish? And the FTC guy said, no, it's not. So, and that's, of course, that's unofficial. You can't take it to the bank, but I think that's probably the correct analysis.
Therefore, stay with an English written buyer's guide, since it's not a Hispanic
Yes.
transaction, correct?
That would be true, yes.
Yeah,
Now, there's an exception. There are a couple states that's, I think, generally the rule. There are a couple states. Illinois, though, is one where even if they bring their own person and that's translating, you have to give them a special disclosure saying that, that they signed that said that they brought their own person to translate for them. But generally, I agree with Tom that if they provide their own disclosure, their own translator, that you're not. It's a transaction conducted in English and not Spanish.
Are we supposed to wind up, Georgia? Do we need to quit? One more question and then let's wind it up. Okay.
In Arizona, we have an implied warranty that also is on that window sticker. And I've seen a lot of dealers in Arizona that don't put the stickers up, and they say, well, nobody enforces it. And
Yeah,
that's why they don't use them.
Well, the problem with anything like that, even if you've got a provision of law that the state folks aren't enforcing, a plaintiff's lawyer can always bring a lawsuit and say that your failure to comply with the state law constitutes an unfair or deceptive act or practice under state law, bring a UDAP claim against you, and that's usually, attorney's fees, double damages, triple damages, that kind of thing, and those lawsuits can be fairly serious. We've been instructed to wrap it up, and we have to, but I wanted to throw up this list of resources. These are places we send people. The first one is a pamphlet put out by NIADA and the American Financial Services Association called Understanding Vehicle Finance. We recommend dealers, in first place, read it. Second place, have it out for their consumers. NIADA puts out a privacy safeguarding management guide. Your state ADAs and IADAs are valuable sources, as are your national trade associations, valuable sources for compliance information. The state government websites can sometimes be good. We have a legal desk book. We have a monthly newsletter, Spot Delivery. We handed out a copy of that to you. There are other equally as good things in the marketplace besides ours. You ought to look around and find ways to keep up on developments. There are trainers and consultants all over this business. Some are good, some are not so good. The good ones, you just need to use due diligence, make sure you're hiring people that your friends and other 20 group members and the like have had good experiences with. And finally, the FTC's website is probably one of the best things out there for businesses. With that, we're out of time. We'll be in the exhibit hall tonight. We welcome you to come by and visit, ask more questions. We'll visit with you until we drop. Thanks very much.